7A ಬಗ್ಗೆ. No, that's Muzaffar alwa.
No, my lord, Sita Soran. This is 7-bench judgment. I just want to read one paragraph because I unfortunately argued this about few months before this judgment came before a coordinate bench and my argument was non-suited. It was not accepted.
Now it is suited here.
I'm only making a feeble attempt. My lords. As an officer of the court, I'm
Sir.
just.
Yes, ಆಮೇಲೆ
My lords, may please have para 122. My lords,
legislatures.
illa 122 on bari tavu nodidre.
Yes.
Para 122. Under section 7 of the PC Act, the mere obtaining, accepting or attempting to obtain an undue advantage with the intention to act or forbear from acting in a certain way is sufficient to complete the offense. It is not necessary that the act for which the bribe is given be actually performed. The first explanation to the provision further strengthens such an interpretation, which is expressly states that the obtaining, accepting or attempting.
No, the main issue was parliamentary privileges in this. Whether they are absolved, Prevention of Corruption Act is applicable. Adu voting thane?
Voting.
Ah, yes.
No, my lords, but I only want to draw this. Attempting
We'll
is
consider it, yes.
to
There is one
obtain an
more.
undue advantage.
Later judgment ಇದೆ ಒಂದು. Where is that Muzaffar Ali?
Muzaffar Ali.
Where is that? 10th July 2024.
Please, my lords.
That's also on 7A, but of course that was after trial.
Please.
The apex court says even under 7A, you should do some kind of inquiry and then lay a trap. Whether there was demand at all.
My lords, there is
That's
a
what-
transcript here where he says, okay, give me this much money.
Fail ಯಾಕಾಯ್ತು ಮತ್ತೆ?
ಅವ್ನು ಬರ್ಲಿಲ್ಲ, ಅವನಿಗೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಹತ್ಬಿಟ್ಟಿದೆ.
ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ಬಂದಿತ್ತಾನೆ.
ಏನೋ ಬಂದಿತ್ತೋ ಗೊತ್ತಿಲ್ಲ ನಿಮಗೆ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಅಲ್ಲಿ ಐ ಕ್ಯಾನ್ ಪಾಯಿಂಟ್ my lords, I'll only say I can point out, my lords may have my statement of opinion. I'll only read. I'll only read one thing. I'll read the transcript.
Lord, I was working as my lord revenue inspector. Lord, on 24/2/2023, the respondent number 2's application was rejected for transfer of kata.
Oh, no work pending.
Lord, I have rejected that application. After 1 month, on 29/3/2023, Lord, complaint is lodged alleging that I had demanded my lord bribe on 22/2023. By that time, my lord, his application was rejected. And thereafter, my lord, thrice they have attempted, Lord, they have postponed, trap is failed. Lord, I have produced the merger to show that, Lord, trap page 45.
Times you tried. Huh? You tried 3 times.
Unfortunately for us, my lords. I'll only read out one.
29/3, my lord, 30.
ಏನಾದ್ರೆ ನೀವು ಆಡಿಯೋ ರೆಕಾರ್ಡಿಂಗ್ ಇಟ್ಕೊಂಡು.
Nevertheless, that is why I'm trying to say, my lords, this Supreme Court judgment says the proviso has to be read into to interpret the
So, all
provisions.
right. Now you will try him. What do you do?
My lords, attempting in itself is an offense is what now is held. That is what I want to read.
Sir, that's on a different footing. We'll answer that. No issues. Now you will try him. What do you do?
My lords, the statutory provision provides
Trial
that attempting in
no,
itself.
Statutory provision provides a different thing, that is to initiate the proceedings. Now you want to try him. There is, according to you, there is demand, no acceptance. Now according to him, work was done, everything was over. Ultimately, he will get acquitted. Because impossible to prove.
No, my lords.
No tests. Nothing. He is not caught red-handed for 7A. Somebody else has not received the amount on his behalf. Everything is failed. So for what satisfaction should a trial be permitted?
My lords, the trial be permitted
Just because you have laid a trap?
No, my lords.
Then
I would rather beg to submit that if the statutory provision is read.
that is for initiation, all right. Now you have initiated.
I would beg to differ, my lords. My lords, may please read it. The Supreme Court says that. They say that the proviso may be
We will
read, my
accept,
lords.
sir.
One proviso other
We
bodak pudi.
will accept. What do you prove now? Tell me.
What I'm proving is the moment he says he'll take the bribe or even he attempts, the offense is complete.
Complete.
Please, that's what the proviso says, and that is what this interpretation says.
But, my learned friend had made the very same submission before the coordinate bench,
Please, my
which
lord,
is rejected.
then I did not have the advantage of this judgment. This judgment now is in my favor is only.
You did not have the advantage of this judgment. Then
Please, my lords.
you won't have any advantage of this judgment now.
I'll only, as I said, my lords, in the beginning, I'll at least make an attempt to convince my lords
Oh, yes,
otherwise.
sir. failed trap, you don't go back saying failed attempt. ಹೇಳಿ.
No, my lords,
Ah.
this only one paragraph I'll read, my lords.
Yes,
may
sir.
please see. Paragraph 122.
Hmm.
My lords have paragraph 120.
Yes.
Under section 7 of the PC Act, the mere obtaining, accepting or attempting to obtain an undue advantage with the intention to act or forbear from acting in a certain way is sufficient to complete the offense. It is not necessary that the act for which the bribe is given be actually performed. The first explanation, I'll read out the first explanation later on. First explanation to the provision further strengthens such an interpretation when it expressly states that obtaining, accepting, or attempting. I stress, my lords, attempting to obtain an undue advantage shall itself constitute an offense, even if the performance of the public duty by a public servant has not been improper. Therefore, the offense of a public servant being bribed is pegged to receive or agreeing to receive the undue advantage and not the actual performance of the actor. So his defense that, he had already rejected is also doesn't come to his recuse. Act for which the undue advantage is obtained. It is trite law that illustrations appended to sections are of value and relevance in construing the text of a statutory provision.
ಹೇಳಿ sir.
ಅಲ್ಲ,
ಹೇಳ್ತಾ ಇರಿ. I am
my-
all ears.
My
Tell me.
sincere apologies if I'm eating into my lord's time. I'm only
No,
trying
no,
to
no.
make a feeble attempt.
Not, I am all ears. Tell
My
me.
lords, I'll only say the illustration to the first explanation aids us in construing the provision to mean that the offense of bribery crystallizes on the exchange of the bribe and not require the actual performance of the act. It provides a situation.
Stop. Crystallizes on the exchange of bribe. What do you mean by that?
Agreeing to receive.
No,
My
no, no,
lords,
no, no.
it-
Exchange of
that-
bribe.
that is why a proviso may be read.
No, no. You
Proviso
read the
होती है.
judgment. The Supreme Court says it gets crystallized on exchange of bribe. What do you mean exchange of bribe?
My lords, exchange.
Exchange of bribe is not intention to exchange of bribe, but an act of exchange of bribe.
My lords, attempting also is an offense. A main paragraph.
Supreme Court begins that way, but Supreme Court ultimately holds there should be exchange of bribe.
Munde one line extra, last I'll say. It provides a situation where a public servant, yes, asks a person P to give him an amount of 5,000 rupees to process his routine ration card on time. I'll re-stress it once again. A public servant, yes, asks a person P to give him an amount of 5,000 rupees to process his routine ration card application on time. Finished. Yes, is guilty of an offense under this section. Only on the fact that he has asked. In itself, they are saying is an offense. He has asked, there is
One minute.
no doubt about it here.
1 minute. What was the date on which he asked?
My lords, the Mahazar says so, the
Yavat-
trap Mahazar.
Yavat?
My lords, on 15/3/2023,
When was the application rejected?
24/2/2023.
Why would he ask after
My
rejection?
lords, that is why I'm saying whether
No,
he
one
actually
minute.
does the
One
act.
minute, sir. Why would he ask after rejection?
My lord, whether-
ಅಪ್ಲಿಕೇಶನ್ ಪೆಂಡಿಂಗ್ ಇದ್ರೆ ಅವ್ರ ಹತ್ರ ಕೇಳ್ಬೇಕು. ರಿಜೆಕ್ಟ್ ಮಾಡಿ 1 ತಿಂಗಳಾಗಿದೆ. Why would he ask?
Reject ಮಾಡಿದ್ದು the trial ಅಲ್ಲಿ whether it was rejected before, after is a fact finding endeavor.
Why?
Lords.
Sir, dates are stubborn. They won't change. Whether it is before the trial court or before this court. What evidence do you need? 15th February nadu.
Yes.
27th February in a trial cannot become 27th March. ಅದು ಫೆಬ್ರವರಿನೇ ಇರುತ್ತೆ.
But in the
Sir,
complaint.
facts and dates are very stubborn, sir. They don't change.
I don't disagree, my lords, but whether it was actually rejected on that day, whether he did it or no, all of it
The
is a
document
outcome of a
ಹಾಕಿಲ್ವಾ?
trial now.
Document ಹಾಕಿಲ್ವಾ? Rejection document.
Not in the complaint itself says that my application is rejected on 22/2/2023, page 30, my lord. He refers the application.
I think you should save your energy for a better case.
My lords, sir,
ಅದು ಇವತ್ತೇನ್ ಹಾಕಲ್ಲ, ಅವತ್ತೇ 7th ಗೆ ಹಾಕೋಣ.
illa, my lords may pass appropriate orders. This is all is my submission because it is an admitted fact that the trap has halfway succeeded.
ಅಂದ್ರೆ ಮಧ್ಯದಲ್ಲಿ ಹೋಗ್ಬಿಟ್ರೆ ವಾಪಸ್ ನೀವು.
ಅವ್ರು ನಮ್ಮ ಅಲ್ಲಿ ಹೋಗಿ 3 ಬಾರಿ ನಾನು ಮಾಸ್ಟರ್ ಡ್ರಾ ಮಾಡಿ ಟೀಮ್ ತಗೊಂಡು ಹೋಗಿ ನಿಂತಿದ್ದೀನಿ.
ಟೀಮ್
That is the trap.
ಟೀಮ್ ತಗೊಂಡೋಗಿ ಏನ್ ಮಾಡಿದ್ರಿ? ಟೀ ಕುಡ್ಕೊ
ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಅವರು, ಅವ್ರಿಗೆಲ್ಲೋ ಗುರ್ತಾಗಿ ಓಡೋಗ್ಬಿಟ್ರು ಅವರು. And my lords, ultimately my
ಈಗ
another
ಏನ್
argument.
ಗೊತ್ತಾ? The problem is you should set your house in order. WhatsApp message ಹೋಗಿರುತ್ತೆ ಅವ್ರಿಗೆ.
Ado, my lords, that is beyond the reach. Nevertheless, there is one more judgment.
ಹಾ, ಕೊಡಿ.
It's a Bombay High Court judgment, may
All right.
have some kind of persuasive value to my lords. Paragraph 19 may be seen.
ಇದೆಲ್ಲ ಲಾಂಗ್ ಬಿಫೋರ್ ನೀರಜ್ ದತ್ತ.
Please, my lords.
Hmm.
But again, that's actually.
Hmm.
As can be seen, both these sections are defining as well as penal sections by themselves. The sentence provide, my lords, I'll come to
This
next.
was the law. I'm not saying this was the law till recently.
This Supreme Court judgment, no, judgment where they
That's-
say an attempt also in itself, because this, my lords, we are having a, ultimately my only submission would be trap is not something that, it's a evidence collecting mechanism where we live trap him and say that he has committed the offense. Nevertheless, if we take the only the statutory provision and attempting alone is construed as an offense, as read in the
See,
proviso,
There are a slew of judgments of the apex court which say demand and acceptance should be there. If demand is there, no acceptance, no offense. If acceptance is there, no demand, no offense.
but this proviso has not been dealt there. Supreme Court has had an occasion to deal with this proviso. And especially in the wake of they highlighting the attempting fact.
We'll see.
And-
We'll deal with your
And,
submission.
and proviso, my lords, finally, only one thing. Proviso also reads that if he asks also, it's an offense. That's what the proviso is reading.
Let's see. Yes.
Please.
ಅದು seventh ಬರ್ಲಿ. Entry ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ.
Interim order ಇದೆ. But one more matter, my lord, this may be.
ನೀವೆಲ್ಲ ಕನೆಕ್ಟ್ ಮಾಡಿಸ್ಕೋಬೇಡಿ ಇವತ್ತೇ.
ಹಾ.
ಸೆವೆಂತ್ ಬರ್ಲಿ.
Seventh thing,
Yes.
ಅಲ್ಲ, sixth thing memo ಮಾಡಿ.
ಹಾ.
I'm telling them. On a lighter note, I'm sorry.
But,
Compilation.
Petition 19406.
Tag this along with that. Yes, madam.
19406.
Please.
140.
obliged.
Yes.
But
Deeply
next
obliged.
matter is, my lord, covered by my lord's order.
ನೆಕ್ಸ್ಟ್ ಇದೆಯಾ?
ಹೌದು.
ಆಯ್ತು.
Next
ಅದು
is-
ಸೆವೆಂತ್ ಬರ್ಲಿ.
ಅಲ್ಲ, ಇದು 7A ಅಲ್ಲ.
ಮತ್ತೆ
Sub registrar registered a document. I am also read as a, not,
ಸಿಕ್ಸ್ತ್ ಬರ್ಲಿ ಬಿಡಿ. ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ.
this covered,
ಎಸ್ ನೆಕ್ಸ್ಟ್.
not, serial number
Obliged, deeply
142
obliged.
may be clubbed along with, my lord, writ petition 3659, my lord. Again, sub registrar registered a deed,
ಬೇಡ, ಯು ಮೂವ್ ಇಟ್ ದಿ ಮೆಮೋ ಪ್ರೊಸೆಸ್. ಎಸ್, ಡೋಂಟ್ ಕ್ಲಬ್. ನೆಕ್ಸ್ಟ್.
43 minutes. Proposed it as a case. 7 minutes.
ಆಯ್ತು, ಸೆವೆನ್